Hey everybody, we're hearing stuff about disability accommodation, but religious accommodations have also been in the headlines. Here's a fast important update on your religious accommodation rights at work and what last week's legal opinion means for you. On September 18th, the Justice Department's Office of Legal Counsel issued a formal opinion to the EEOC about religious liberty in the federal workplace. The three big takeaways after I reviewed it are: first, the old de minimis test, tiny cost for denying a religious accommodation is gone. That makes sense. After the Supreme Court's decision in Groff versus DeJoy, an agency now has to show a substantial burden in the overall context of the agency's work to refuse your accommodation. Two, the old appearance of official endorsement test for restricting religious expression in the workplace is no longer the rule after Kennedy versus Bremerton. Agencies can still stop coercive or disruptive conduct, but if they allow comparable non-religious private expression, they can't single out religious expression just because it looks like endorsement. Three, even with the president's return to in-person work directive, agencies can use situational telework as a religious accommodation. Think discrete days or short windows tied to observance. And in some circumstances must consider it, especially where they already allow similar ad hoc telework for secular reasons. So what does all this mean in real life? Well, if your faith requires Sabbath observance, daily prayer times, fasting, holy days, or travel to worship, your agency must engage in a case-by-case interactive process to find a reasonable accommodation. Schedule swaps, flexible hours, comp time, reassignment of non-essential tasks, or situational telework tied to specific observances. No more, hey, we can't do that because that's against our policy. Policy sets the default, but the law creates the exceptions. If someone tells you we can't approve religious telework, RTO means everybody has to be in the office, here's your response. That's not true. The OLC opinion confirms situational telework remains available for religious accommodation. Title VII requires a fact-specific analysis. Again, to this extent, it's very similar between the disability law and the religious accommodation law. There's an individualized assessment required. So if you're told that your personal private religious expression at work is prohibited because it might look like government endorses religion, remember that endorsement appearance test is no longer controlling. The line is now neutrality and workplace functioning. If private expression is generally allowed for non-religious items, then they must allow it for religious items. However, coercion or disruption is never allowed. Here are a few pro tips to protect yourself. So first, make a focused request in writing. Tie your religious practice to the specific schedule or location adjustments you need and to your essential duties. Offer practical options, propose shift swaps, flex time, or situational telework limited to particular observances. Short pilots with check-ins show good faith and flexibility. Ask them to show their work. If they deny, they must point to concrete, job-specific reasons amounting to substantial hardship, not general preferences, coworker resentment, or, hey, that's our policy, nobody gets to telework. Keep it professional and documented. Save emails, notes of meetings, and any rationale they provide. Bottom line, your agency cannot use one-size-fits-all policies to avoid accommodating sincere religious practices or reasonable accommodations required by disability law. The government's own legal guidance now says so explicitly, and what's good for disability law should also be true for religious discrimination law. My name's Sean. We represent federal employees. If you're running into roadblocks, feel free to reach out to see if our offices can help you. Thank you, everybody, for your time and support, and hope you have a great day.